Day 16, we're talking about workers' comp injuries and post-accident reporting. This is Matthew Struck with Treadstone Risk Management. This is the 16th day of our 30 Days of Insurance and Risk Management vlog series. Let's get at it. So the first rule in workers' comp is kind of like real estate. Instead of location, it is document. And we're talking about more than just documenting the really bad injuries that might occur on the job site or in the course of an employee doing their duties. We're also talking about documenting near misses or some of the small nicks and things like that happen. The first thing I'm going to caution you about is if you turn a blind eye to those kind of near misses and those small little kind of just minor injuries and things like that, and you don't document the occurrences, you could end up with some issues in the long run. I had one case where a injured worker cut themselves. They refused medical attention, and then a week later they ended up with a massive blood infection that cost hundreds of thousands of dollars to treat, and it was all it became very tough to mitigate the cost of that claim because it wasn't documented right from the get-go what happened, and a supervisor didn't stay on top of the employee just to make sure that they were okay in the hours and days following the event. All right, so what are some of the benefits of post-injury or post-accident reporting and documentation? So the first of which is it creates a record, right? So you have now a written record of the facts and the circumstances that surrounded the event. It also helps document things like the location, the date, the time, and the other circumstances that contributed to the event that might have been either standard circumstances that the employee would come up against or non-standard things that kind of came out of the blue and ended up resulting in that claim. It also begins the claims reporting and rehabilitation process. So if an employee is injured and you don't do any documentation, sometimes the process of actually getting that employee into the rehabilitation process can be stunted if someone doesn't understand the next step or know what to do next to help the employee, or the employee themselves is unaware of what they need to do next. It also identifies the internal factors that need to be addressed in the future. And those internal factors could be the nature of the job, could be the environment that was around the employee when these things happened. It could also be a shortcoming in training that's associated with performing certain job duties. So it's very important that within your documentation and your post-accident reporting that you actually include some area of narrative so that both the employee and the supervisor can give some feedback on what they felt was the issue that could be corrected so that these types of claims are either less damaging in the future, less injurious, or able to be avoided in the future. Like I stated with the earlier example, this documentation also provides some protection to the employer if the employee refuses medical treatment and then in the future there is some claim of injury that relates back to the prior event. And the big scenario here is when an employee has some kind of event that happens on the job, you don't document it, and they say, oh, well, my shoulder's just sore or whatever. They go home over the weekend and they go and, rake their lawn or, do home remodeling or something, or go work another job, and they injure themselves there. And then they come back on Monday and they say, oh man, my shoulder's really killing me from that thing that happened on Friday or Thursday. And we don't really know whether or not that's the case or not. It could have been something that happened at home or away from the job, but because we didn't document, we have no way to push back on it. You almost have to accept the claim, especially in states that are very worker-friendly. New Jersey is one of those states where workers' compensation coverage is essentially strict liability, meaning if the employee is hurt, 99.9% of those injuries are going to have to be covered under the workers' comp program. And then finally, it establishes an organizational culture of accountability and safety. All right, so if you're not documenting things, your workforce is going to see that. They're going to understand that you're not necessarily tracking these things, and it's not present, it's not in their face, right? But if after each one of these events, you're documenting, you're getting particulars, you're getting information from the employee, from the supervisor, from witnesses that were present, they're going to know that in the future they can't just kind of make something up or kind of materialize or manifest an injury without any kind of backup or any kind of support. They're going to need to actually only file legitimate injuries and claims, as opposed to in some cases there can actually be some fraud associated with workers' comp claims. All right, so let's talk about some best practices. So the first best practice that I'm going to talk about is requiring that the post-accident or post-injury report form be completed by the employee and reviewed by the supervisor. You could actually have two separate forms or one form that has two sections. And the point of this is we want the employee's actual accounting of what happened and why the injury or the accident occurred. The second reason is we want the supervisor to not only be informed, but also to include their input and to be made aware of any seriously hazardous or threatening conditions or shortcomings within the operations or the training that's present that they could have a hand in fixing so that this doesn't happen again in the future. As I mentioned with the two forms, states like New Jersey, it's very important to have two separate forms. The employee fills one, the supervisor fills the other, because in New Jersey there's actually some big shortcomings or restrictions in terms of doing interrogatories and other types of discovery when it comes to a legal claim that might be associated or a lawsuit that might be associated with a workers' comp claim. And so if you only have the employee documentation and you don't have the supervisor documentation, or vice versa, you could end up only getting one side of the story and not necessarily be able to defend yourself against a claim or try and limit the amount of money that a claim costs. And so you need to have those two documents in certain states. All right, require that both individuals sign off on the documentation. Very important, because if someone's filling out something but they don't sign it, there's not going to be any legal standing to say, yes, they acknowledged that all of this information was correct. Use a template form, but make sure to tailor it to your operations or to specific job duties or specific departments or divisions within your organization. So you could use a standard reporting form, but remember that standard reporting form could apply to a wide range of industries or a wide range of different types of organizations. Make sure that you're tailoring it to your specific entity. All right, include your attorney and risk manager in creating this documentation and thinking up the questions, and also formatting and the types of questions are important. Typically, a one-page report is sufficient for either the employee only or the supervisor only form. It could be 2 pages or a little bit more than 1 page if it's a combined form for both. But including your attorney and your risk manager is going to allow them to give you input into what information might be needed to be collected and how to collect that information, whether it's just a yes or no answer, multiple choice, long form, fill in the blank kind of situation. And always keep people to task when it comes to those long form answers. When it says, when your question asks what could be done in the future to prevent this, and the answer is nothing or be safer, okay, you need to push back and say, look, that's not sufficient. We need some real meat here in order to be able to understand what we can do in the future to stop these things from happening, or at least make them less severe. All right, if any witnesses are present, make sure to question them or get some kind of basic written statement from them within 24, 48 hours after the event, so that the event is still fresh in their memory. You could have a specific form for this, or what a lot of employers do is they simply have the witness employee, or just the witness in general, just complete a email that's a 1-paragraph email that kind of talks about what happened around the event and the particulars that they noticed that led up to the injury or the accident. Require sign-offs by the employee if they are refusing medical attention, okay? Employees might refuse medical attention for a wide range of things. Like I mentioned before, it could be because they have this other injury or something that's nagging at them and they want it covered by workers' comp, because workers' comp doesn't require them to include any copays or deductibles or anything like that. They don't have to dig into their own pocket. So you have to make sure that they sign off on not having medical treatment, because that could be important in terms of setting the table for pushing back on a claim that might be frivolous or fraudulent in the future. Include a couple of questions related to the circumstances that led up to the incident. A lot of times, an accident or an insurance claim is kind of like a set of dominoes, right? There's a number of dominoes that have to fall in order for the last one to hit the ground, and the last one is the claims, the really climactic, catastrophic or bad result that happens. But there are things that happen along the line that could act as a circuit breaker, where if you were able to identify something that led up to that claim or that injury, you could stop that chain of events from happening before it gets to that really bad conclusion. All right, think about including questions about activities related to the employee's activities outside of work. Now, some states have varying ability for the employer to ask these questions, but in the states where you can, and this is why you need to include your attorney and your risk manager, in the states where you can, it can be actually crucial information. The employees are complaining of a shoulder injury. Do they play softball every other day with a team? Are they moonlighting as a contractor or some other kind of physical labor that might generate a claim or manifest itself in a similar type of injury? All of that information could be really important in terms of painting the picture around the injury. All right. Nowhere on the form should there be any statements about an injury or anything being compensable and covered by workers' comp insurance. Okay? Let the professionals, let your claims professionals, let the insurance company, let your risk manager evaluate that. Okay? Never make any kind of assertions, and make sure that the supervisor is advised that they can't necessarily say, oh, okay, go take care of that. It'll be covered by workers' compensation. All right? Not necessarily that you're going to get stuck with a claim, paying for a claim that you wouldn't normally have to, but it's about setting expectations. If the employee thinks it's going to be covered under workers' comp and it's not, but you've told them it is, they're going to be irate. And so you're going to have to deal with that going forward. So it really boils down to a employee relations kind of aspect. All right, so that's all I have. I'm going to throw in a little plug here for a couple of the references or outside resources that I've included on the text-based article. Point to the Cape Scatcherd, New Jersey Workers' Comp blog. Great resource. You should definitely check it out. If you just Google New Jersey Workers' Comp blog, it'll come up. They have tons of information in there. It's really written from the legal side of things. So if you want, something other than a insurance guy, risk management guy's perspective, you can definitely check that out. There's a lot of very interesting cases that they've written opinions on, and there's also a lot of very interesting circumstances that you might not have thought about in the past that could give rise to a claim, or might be something that you could use to defend against a claim that you feel is fraudulent or frivolous within your system. All right, so that's it. Day 16's in the books. We're on the way downhill. We've got 14 days left, so we'll see you on day 17. Remember, make sure, like, subscribe, share, comment, send us your questions. We want to hear from you. We're out.